My name is Robert Parker, and I never thought I'd be sharing this story. But what happened to my daughter Emma changed our lives forever, and maybe by telling it I can help someone else facing the same battle. 3 years ago, Emma was in a serious car accident that left her partially paralyzed, requiring a wheelchair for mobility. She was just 19 years old, bright, determined, and refusing to let her disability define her. After months of rehabilitation, she moved back home with me into the house where she'd grown up, the house my late wife and I had chosen because of its beautiful neighborhood and sense of community. What we needed seemed simple enough: a wheelchair ramp at the front entrance. Nothing fancy, just a sturdy, practical ramp that would allow Emma to enter and exit our home independently. I hired a professional contractor who specialized in accessibility modifications, made sure the design was subtle and matched our home's exterior, and had it installed within a week. The ramp was a game-changer for Emma. For the first time since the accident, she could come and go without depending on me to help her up and down the steps. Then the letter arrived. A formal notice from the Oak Ridge Estates Homeowners Association, claiming the ramp was an unauthorized exterior modification that violated community guidelines. The letter was signed by Victoria Harrington, HOA President, demanding immediate removal of the unsightly structure within 14 days or face daily fines. I was stunned. This wasn't about aesthetics or property values. This was about my daughter's basic right to access her own home. When I called Victoria to explain the situation, her response left me cold. "We all have problems, Mr. Parker," she said dismissively. "But rules are rules, and exceptions can't be made for everyone with a sob story." I had no idea then that this was just the beginning, that Victoria's hostility toward our wheelchair ramp would escalate into a battle that would eventually lead us to a courtroom, where my daughter would teach everyone a lesson about justice that none of us, especially Victoria Harrington, would ever forget. The morning after I received the HOA letter, Victoria Harrington herself appeared at our doorstep. She didn't ring the bell or knock. Instead, she was taking photos of our wheelchair ramp with her phone, muttering to herself about property values and eyesores. When she noticed me watching from the window, she straightened her designer blazer and approached the door with a clipboard in hand. "Mr. Parker," she began without greeting, "I wanted to personally emphasize the seriousness of this violation." Her gaze drifted to the ramp with undisguised disgust. "This structure was installed without proper approval and drastically alters the uniform aesthetic of our community." When I explained that the ramp was medically necessary for Emma, Victoria's expression hardened. "Medical necessity or not, there are procedures. You should have submitted plans for a more discreet solution. Perhaps an entrance at the back of the house." She glanced toward our backyard, which had a steep drop-off that would make a ramp there impossible and dangerous. That first confrontation was just the beginning. Over the next 2 weeks, we received 3 more increasingly threatening letters. Each one detailed specific violations of community guidelines, claimed our ramp, diminished neighborhood appeal, and increased the daily fine should we fail to comply. The third letter included photos of other homes in the neighborhood with the caption, "Examples of properties maintaining community standards. Notice the absence of unsightly modifications." Then came the monthly HOA meeting. Emma insisted on attending with me, determined to explain her situation directly to the board and our neighbors. As we entered the community center, the room fell uncomfortably quiet. Victoria was standing at the podium mid-sentence, and paused to watch Emma maneuver her wheelchair into the room. "Well," Victoria said with a tight smile, "speaking of community violations, here's Exhibit A." A few uncomfortable chuckles rippled through the room. "Now everyone can see what we're dealing with." For the next 20 minutes, Victoria presented a slideshow on maintaining aesthetic standards, featuring a photo of our home with the ramp prominently displayed as a prime example of unauthorized modifications. She referred to it as the Parker problem, and suggested that allowing such accommodations would lead to a slippery slope of other modifications. Who knows, next it'll be backyard carnivals and front yard hospital equipment. Emma sat stone-faced through the entire presentation, her knuckles white as she gripped her wheelchair arms. When the floor opened for community comments, she raised her hand. Victoria deliberately called on 5 other residents before reluctantly acknowledging Emma. "The Americans with Disabilities Act," Emma began, only to be cut off. "This is a private community, dear," Victoria interrupted, "not a public accommodation. Different rules apply." She smiled condescendingly. "But thank you for your input." As we left the meeting, a $500 fine notice was placed on our windshield. The following week, another letter arrived threatening legal action for continued noncompliance. The daily fines had now increased to $150, with a note that a lien could be placed on our property if the fines remained unpaid. The final blow came when we discovered that Victoria had started a petition among neighbors to address the Parker eyesore, claiming the ramp was decreasing property values by up to 15%, a completely fabricated figure with no evidence. The petition had already gathered 30 signatures, many from neighbors who had never even spoken to us about our situation. When I called a lawyer friend for advice, his response was discouraging. HOA cases are complicated and expensive, he said. They have their own legal fund built from everyone's dues. They can outlast most homeowners in court. But then Emma, who had been listening to the call, took the phone from my hand. Tell me exactly which laws apply here, she said, reaching for a notebook. And don't leave anything out. I'll never forget the night after that HOA meeting. Emma, who had been so strong through her recovery, through the painful physical therapy sessions, through learning to navigate the world in a wheelchair, my unbreakable daughter, finally broke down. I found her in her room, surrounded by the HOA letters and notices, tears streaming silently down her face. "Why do they hate me so much, Dad?" she whispered, her voice catching. "It's just a ramp. It's just so I can get into my own home." She looked up at me and I saw something in her eyes I hadn't seen since the accident, a deep, raw vulnerability that cut straight to my heart. Do they think I want to be in this chair? Do they think I wouldn't give anything to climb those steps like everyone else? That night, I sat beside her bed like I used to when she was little, watching her finally fall into an exhausted sleep. I felt utterly helpless. The HOA fines were piling up. We were approaching $3,000 already, money we didn't have to spare after Emma's medical bills. Each day brought new stress, new threats, new reminders that our home, the place that should have been Emma's safe haven, was now the center of a battle we hadn't asked for. The pressure began affecting us in different ways. Emma started avoiding going outside altogether, afraid of running into neighbors who had signed Victoria's petition. I found myself losing sleep, waking up at 3 a.m. to reread HOA bylaws and search for some loophole, some protection we might have missed. Meals were often forgotten, conversations became centered solely around strategies and worries. The simple joy of being home had been stolen from us. The neighborhood itself became a minefield of uncomfortable encounters. Some neighbors crossed the street to avoid talking to us. Others stared openly at the ramp when walking by, as if it were some bizarre art installation rather than a necessary accessibility feature. A few sent anonymous notes suggesting we think of the community and find a more suitable place to live. But not everyone turned against us. Mrs. Abernathy, an elderly widow next door, brought us homemade bread and quietly told Emma she thought the whole thing was absolute nonsense. The Johnsons from down the street stopped by one evening to express their support, explaining they had voted against the petition at the HOA meeting. And Mr. Ramirez, whose son used a wheelchair before moving away for college, offered to speak on our behalf at the next meeting. These small acts of kindness were islands of support in a sea of hostility, but the division in the neighborhood was palpable. Former friends became coldly polite, community gatherings became tense, and the sense of belonging we'd once felt had evaporated completely. The turning point came on a Sunday morning. Victoria Harrington was leading a small group of board members on what they called a compliance walk, essentially touring the neighborhood looking for violations. They stopped in front of our house, clipboards in hand, making a show of documenting our ramp yet again. Then Victoria spotted Emma watching from the window and had the audacity to wave with a smug smile before making an exaggerated frown and pointing at the ramp. Emma wheeled herself away from the window, but instead of retreating to her room, she went to the dining table where her laptop was set up. I watched as she opened a new document and typed at the top, Parker vs. Oak Ridge Estates HOA, Legal Strategy. "We're not moving," she said without looking up. "This is our home. And we're not removing the ramp either." Her fingers paused over the keyboard, and when she looked up at me, the vulnerability I'd seen before had been replaced by something else, determination, anger, and a spark of something I hadn't seen since before the accident. "They picked the wrong family to bully, Dad," she said. "I'm going to fight back. And I'm going to win." What I didn't know, what none of us knew, was that Emma had been quietly preparing for this moment for months. In the weeks following her hospital discharge, during those long hours alone while I was at work, she hadn't just been adjusting to her new reality. She had been studying. "Remember Mom's cousin Julie?" Emma asked me that evening as she organized folders on her laptop. "The one who works as a paralegal in that civil rights firm?" I nodded, remembering my late wife's cousin who had visited us a few times over the years. We've been talking almost every day since the first HOA letter arrived. She's been teaching me everything she knows about housing law. Emma turned her laptop around to show me dozens of PDFs, legal articles and court cases involving HOAs, disability rights and housing discrimination. There were pages of neatly organized notes, highlighted sections of the Fair Housing Act, and detailed annotations of our own HOA bylaws. She had even created a timeline documenting every interaction, every letter, every fine, complete with photographs and scanned documents. I've been recording everything, she explained, pulling out her phone. Every conversation, every meeting. Arizona is a one-party consent state, so it's completely legal. She played a crystal-clear recording of Victoria's mocking comments at the HOA meeting, followed by another from the compliance walk, where Victoria can be heard saying, if she can't use stairs like a normal person, she should live in one of those special communities for disabled people. My first instinct was to call a professional attorney. This was too important, too complex for DIY legal work. When I suggested this, Emma's response surprised me. Dad, we can't afford a good disability rights attorney. The ones who win these cases charge $300 to $400 an hour, and we're already drowning in medical bills and HOA fines. She squeezed my hand. Besides, I've already spoken with 3 lawyers for free consultations. They all said the same thing. We have a case, but it would cost at least $20,000 to fight with no guarantee of winning. But Emma, representing yourself against their legal team, is exactly what they don't expect, she finished. They're counting on us either giving in or hiring some overworked general practice lawyer who just wants a quick settlement. They're not prepared for someone who's studied specifically for this fight. Over the next 2 weeks, Emma's preparation intensified. Julie sent over legal templates and reviewed Emma's drafts. Emma discovered that our HOA had violated not just the Fair Housing Act but also several provisions of the Arizona Fair Housing Act and local county ordinances. The wheelchair ramp fell squarely under reasonable accommodations that HOAs were legally required to permit. More damning was Emma's discovery that 3 other homes in the neighborhood had been granted exceptions for various exterior modifications, a decorative fountain, an oversized gazebo, and a non-standard fence, all approved personally by Victoria Harrington for her close friends on the board. Emma found the approvals buried in meeting minutes from the past 2 years. Most significant was Emma's research into Victoria Harrington herself. Through public records and social media, Emma discovered that Victoria had a history of discriminatory behavior. Before becoming HOA president, she had unsuccessfully petitioned against an accessible playground in the nearby public park, claiming it would attract undesirable elements to our community. There were also Facebook comments where Victoria complained about special accommodations ruining the neighborhood aesthetic. The final piece came when Emma created a survey for other homeowners, asking about their experiences with the HOA. 4 neighbors confidentially reported that they had been discouraged from installing accessibility features, including a widened doorway, a support railing and a small stair lift, all rejected by Victoria with various aesthetic objections. They've created a pattern, Emma explained as she compiled all this evidence into a bound presentation folder. This isn't just about our ramp. This is systematic discrimination against residents with disabilities. When we received the certified letter informing us that the HOA was taking us to court to force removal of the ramp and payment of all accumulated fines, now totaling over $5,000, Emma didn't panic. She simply opened her laptop and began drafting our response. They think they're scaring us by escalating to court, she said, a determined smile forming on her lips. But they've just given me exactly the platform I need. I've never been comfortable in courtrooms. The formality, the tension, the feeling that one wrong word could change everything, it's overwhelming. But nothing could have prepared me for the anxiety of watching my daughter wheel herself to the defendant's table alone, facing the HOA's team of 3 attorneys in expensive suits, their table covered with leather portfolios and legal pads. The courtroom was surprisingly full. In addition to the HOA board members sitting smugly behind their legal team, several of our neighbors had come. Some supportive, others seemingly there to witness our defeat. Judge Eleanor Martinez, a stern-looking woman in her 60s, surveyed the room with an expression that revealed nothing of her thoughts. Victoria Harrington sat directly behind her attorneys, wearing a tailored navy suit and a subtle, confident smile. She leaned forward occasionally to whisper something to her lead attorney, Jeffrey Williams, a polished man with silver hair and a reputation for ruthlessly winning HOA disputes. His legal firm handled cases for dozens of HOAs across the state, and his retainer fee alone was probably more than my annual salary. When the proceedings began, Williams approached the bench with practiced ease. "Your Honor, this case is straightforward," he began, his voice resonant with authority. "The Oak Ridge Estates Homeowners Association has specific architectural guidelines that all residents agree to upon purchasing property in the community. The defendants installed a substantial exterior modification without following the proper approval process." He gestured dismissively toward our wheelchair ramp. "While we sympathize with Ms. Parker's condition, rules exist for a reason: to maintain community standards and property values." For the next 20 minutes, Williams presented their case methodically, displaying before and after photos of our home that were carefully angled to make the ramp appear as obtrusive as possible. He cited numerous sections of the HOA bylaws, showed property value assessments suggesting that inconsistent exteriors could lower values by up to 15%, and presented statements from several neighbors who claimed the ramp was an eyesore and not in keeping with community standards. Throughout his presentation, Williams referred to Emma as the disabled resident rather than by her name, his tone a carefully calibrated mixture of pity and firm resolve. Several times he glanced at Emma with a patronizing smile, clearly expecting her to be intimidated by his legal expertise and commanding presence. "In conclusion, Your Honor," Williams finished, "while we understand the defendant's desire for accommodation, there are proper channels and appropriate designs that wouldn't violate our community standards. The HOA has been more than patient, offering multiple extensions before being forced to pursue legal action. We ask the court to order immediate removal of the unauthorized structure and payment of all associated fines, which the defendants agreed to be subject to when they chose to live in our community." When it was Emma's turn, the courtroom fell silent. I could see people shifting forward in their seats, curiosity and from some, a hint of secondhand embarrassment as they anticipated watching a young, disabled non-lawyer fumble against seasoned attorneys. Emma wheeled herself to the center of the courtroom, a single folder in her lap. She didn't stand, she couldn't, but she straightened her posture and looked directly at Judge Martinez. "Your Honor," she began, her voice clear and steady, "this case isn't about architectural guidelines or property values. This is about housing discrimination and a pattern of hostility toward residents with disabilities." There was no nervousness in her voice, no hesitation, just calm, focused determination. She methodically laid out her case, presenting the Fair Housing Act provisions that protected reasonable accommodations for individuals with disabilities. She cited 3 relevant precedent cases where courts had ruled against HOAs in similar situations. She distributed copies of her evidence folder to the judge, the HOA's attorneys, and the court clerk. "The law is clear," Emma continued. "Homeowners associations cannot deny reasonable modifications necessary for a disabled person's use and enjoyment of their property. Our wheelchair ramp is exactly such a modification. It allows me basic access to my own home." Then came the moment that changed everything. Emma pulled out her tablet. "Your Honor, I'd like to present evidence of the HOA's discriminatory intent, specifically from Mrs. Victoria Harrington, the HOA President." Williams immediately stood. "Objection, Your Honor. We haven't been provided with any such evidence during discovery." Emma calmly replied, "There was no formal discovery process, Mr. Williams. The court didn't order it and you didn't request it. But I'm happy to provide copies now." The judge nodded. "Proceed, Miss Parker." Emma pressed play on the first recording. Victoria's voice filled the courtroom, clear and unmistakable. "If she can't use stairs like a normal person, she should live in one of those special communities for disabled people." The courtroom fell completely silent. Victoria's face drained of color. Emma played a second recording from the HOA meeting. "The Parker problem. Allowing such accommodations would lead to a slippery slope. Who knows, next it'll be backyard carnivals and front yard hospital equipment." A third recording captured Victoria telling another board member, "I don't care what her disability is. I'm not having our beautiful neighborhood looking like a hospital ward. If we let one ramp in, next thing we'll have bars on every wall and those ugly chair lifts on every porch." With each recording, Victoria seemed to physically shrink in her seat. Her attorneys were frantically writing notes, clearly blindsided by this evidence. Some of the HOA board members had moved away from Victoria, as if trying to distance themselves from her words. Emma continued methodically, presenting evidence of the other approved modifications for Victoria's friends, the survey results from other disabled residents who had been denied accommodations, and Victoria's history of discriminatory actions. Her presentation wasn't emotional or dramatic. It was precise, professional, and devastating in its thoroughness. "Your Honor," Emma concluded, The HOA's actions aren't about following rules. They're about excluding people with disabilities from our community. That's not just against HOA regulations, it's against federal and state law. As Emma wheeled herself back to our table, the courtroom remained utterly silent. Judge Martinez was looking at Victoria Harrington with an expression that had shifted from neutral to something much colder. The HOA's attorneys were huddled together, whispering urgently, while Williams repeatedly ran his hand through his perfectly styled hair, his confidence visibly shattered. For the first time since this ordeal began, I saw fear in Victoria Harrington's eyes. Judge Martinez called for a 15-minute recess after Emma's presentation. When we returned, the transformation in the HOA's legal team was striking. Gone was Williams' commanding presence and confident smirk. Instead, he appeared flustered, his tie slightly askew as he whispered urgently with Victoria, whose face had settled into a rigid mask of barely contained panic. "Before I deliver my ruling," Judge Martinez began, her voice carrying a sharpness that hadn't been there before, "I'd like to address Mrs. Harrington directly." She fixed Victoria with a gaze that could have cut glass. "In my 23 years on the bench, I have rarely heard such blatant discriminatory intent expressed by someone in a position of authority. Your comments are not just offensive, they potentially constitute a violation of federal civil rights laws." Victoria attempted to interject, but the judge silenced her with a raised hand. "I've heard enough from you, Mrs. Harrington. The recordings speak for themselves." When Judge Martinez delivered her ruling, it was comprehensive and decisive. Not only was our wheelchair ramp to remain in place with no further interference, but all fines against us were invalidated immediately. The HOA was ordered to pay $25,000 in damages for emotional distress and harassment, plus all our court costs. Most significantly, the judge issued an injunction requiring the entire HOA board to undergo fair housing training and appointed an independent monitor to review all HOA decisions for the next 3 years. Furthermore, Judge Martinez continued, "I am referring this matter to the Department of Housing and Urban Development for investigation of potential Fair Housing Act violations across the Oak Ridge Estates community." She looked directly at Victoria. "The court strongly recommends the current HOA leadership consider whether they are able to fulfill their duties in a non-discriminatory manner moving forward." The impact was immediate. As we left the courtroom, Victoria was surrounded by angry board members, several of whom could be heard saying, "You need to resign immediately, and you've put all of us at risk." Williams and his legal team were already distancing themselves, packing their briefcases with uncharacteristic haste and avoiding eye contact with their clients. The community's reaction evolved over the following weeks. The first changes were small. Neighbors who had previously avoided us suddenly finding reasons to stop by. Mrs. Abernathy brought a celebratory cake. The Johnsons invited us to their barbecue. Even some who had signed Victoria's petition came by to apologize, often with awkward explanations about how they didn't understand the full situation. Victoria Harrington resigned from the HOA board the following week, and 3 other board members followed shortly after. Rumors circulated that she was selling her house and moving to another community, unable to face the neighbors whose respect she had so thoroughly lost. The most meaningful changes, though, were less visible. Emma began receiving emails and phone calls from disabled residents in other HOA communities, asking for advice on fighting similar battles. A local disability rights organization invited her to speak at their monthly meeting. A law firm specializing in housing discrimination cases offered her a part-time position as a consultant while she finished her degree. 2 months after the court decision, we received a letter from an elderly couple in the community who had been afraid to install handrails on their front steps despite increasing mobility issues. With the new HOA board in place, their request had been promptly approved. "You didn't just win your case," they wrote to Emma. "You changed things for all of us who needed accommodations but were too intimidated to fight for them." Perhaps the most telling change came during the fall community picnic. For the first time, the event was held in a park pavilion with ramp access instead of the community center with its multiple steps. The new HOA president, Mr. Ramirez, whose son used a wheelchair, made it a point to announce that all future community events would be held in accessible locations. As we sat under the pavilion that day, watching neighbors of all abilities enjoying the gathering, Emma smiled at me, a genuine, peaceful smile I hadn't seen in too long. "It wasn't just about our ramp, Dad," she said quietly. "It was about belonging. About having the right to be part of a community, regardless of how you move through the world." The wheelchair ramp at our house still stands, a simple wooden structure that provides Emma independence. But it's become something more than just an accessibility feature. For our community, it's a reminder that inclusion matters more than aesthetic uniformity. For Emma, it's a daily symbol of her courage and determination. And for me, it's proof that sometimes justice doesn't just happen in courtrooms. Sometimes, it starts with the simple insistence on the right to come home. It's been 2 years since that day in court, and I still find myself marveling at how one moment can completely change the trajectory of a life. Emma's victory against the HOA wasn't just about keeping a wheelchair ramp. It became the foundation for something much bigger than either of us could have imagined. Emma returned to college the following semester, but with a new major, pre-law with a focus on civil rights. Her experiences transformed her from a young woman struggling with a new disability into a passionate advocate determined to ensure others wouldn't face the same discrimination. The case that was meant to break her instead revealed her purpose. Sometimes, Emma told me recently, the people who try to exclude you end up giving you your greatest gift. She smiled, that same determined smile I saw the day she decided to fight back. Victoria Harrington tried to push me out of my home, but she accidentally pushed me toward my calling instead. Emma now runs a small but growing nonprofit organization that provides legal guidance to disabled homeowners facing HOA discrimination. What started as a single desk in our spare bedroom has grown into an office with 3 part-time staff and a network of volunteer attorneys. They've helped over 40 families keep their accessibility modifications, from wheelchair ramps to sensory-friendly yard spaces for children with autism. Each victory builds on the foundation Emma laid with her own case. The most powerful change, though, isn't in the legal outcomes, it's in the confidence I see in the faces of the people Emma helps. There's something transformative about watching someone who has been made to feel powerless discover they have rights worth fighting for, a voice worth hearing. If you're watching this and facing your own battle against discrimination, whether from an HOA, a landlord, an employer, or anyone who tries to push you to the margins because of who you are or what you need, remember my daughter's story. Remember that sometimes, the people who underestimate you give you the greatest opportunity to prove exactly what you're capable of. The law is on your side even when it feels like nothing else is. The Americans with Disabilities Act, the Fair Housing Act, and numerous state protections exist because inclusion isn't just a nice idea, it's your right. Document everything. Know the regulations. Find allies. And never let anyone convince you to make yourself smaller or less visible for their comfort. If you've experienced something similar to our story, share it in the comments below. Your experience might be exactly what someone else needs to hear to find the courage to stand up for themselves. And if you're currently facing HOA discrimination, visit Emma's organization website. The link is in the description, for resources and guidance. The wheelchair ramp that caused so much controversy still stands at the front of our house. Sometimes new neighbors move in and don't even notice it. It's just become another part of the community landscape. That's how inclusion should work. Not as something extraordinary or controversial, but as something so natural that its absence would be what stands out. As Emma often says, the fight for accessibility isn't about special treatment. It's about equal access to ordinary life. And that ordinary life, the right to come home, to move through your community, to belong, is something worth fighting for.